Welcome to Tennessee Court Talk. I'm your host, Barbara Peck, and today we are talking about criminal sentencing. This podcast is intended for all audiences. My first guest is Judge Steve Sword of the 6th Judicial District, which covers Knox County. My second guest is Judge Jim Goodwin of the 2nd Judicial District, which covers Sullivan County. And my third guest is Judge Zack Walden of the 8th Judicial District, which covers Campbell, Claiborne, Fentress, Scott, and Union counties. Welcome to you all.
Thank you. Good morning. Thanks for having us.
So let's talk about criminal sentencing. Judge Sword, at what point are we going to have a sentencing hearing in Tennessee?
So you'll have your sentencing hearing after there's been a conviction of a criminal offense, and that can either be through a plea or a trial by jury, and the jury found them guilty.
And what is going to happen at a sentencing hearing?
You know, the biggest misconception I think the general public has about sentencing is that the judge just listens to the facts and determines what do I think is the appropriate punishment for this offense, and that is completely incorrect. You know, the legislature determines what the appropriate punishments are for offenses, and they give us guidance to help the judge to determine where within certain ranges of punishment should fall, and also the manner in which they should be served. And so really the role of the judge is to look at the law first, and then you look at what that person was convicted of, the facts of that particular case, and then you determine what a just sentence is in accordance with the law, not in accordance with what your personal beliefs are, what you think the fair and right thing is. And that's a big misconception a lot of folks have.
Judge Goodwin, what about in your court? When does a sentencing hearing typically happen? How far away from a conviction?
If they're in custody, it's within 45 days, or supposed to be within 45 days. If they're out of custody, probably within 60 to 90 days.
Okay, and it's a separate process than a jury trial. So first we've had a jury trial or a bench trial, I guess, but most likely a jury trial. The jury has convicted, and now we're having a sentencing hearing. So what happens in a sentencing hearing? Are there witnesses? Is there statements?
Most people who are listening, if you're not really familiar, you're probably thinking, well, why in the world does it take 45 days? Or why does it take 60 to 90 days? The thing is, the Tennessee Code requires that we have a pre-sentence report in front of us that's prepared, that gives us facts of the case, defendant's history, criminal history, social history, work history, so that we know all these things. And then we take proof, excuse me, we take proof and hear from the defense and from the state, and they can put on any testimony they want. The defendant has the burden if it's a plea agreement. If it's a trial, then the state has the burden to prove what the sentence should be.
Okay, so let's talk about plea agreements, because most cases actually are a plea agreement, and most cases do not go to a jury trial. So is the sentence always part of the plea agreement, or is it sometimes is and sometimes not?
Sometimes it is and sometimes it isn't. So the vast majority of our pleas, the sentence is agreed to. However, from time to time, they will ask the court for what we call wide open sentencing, which means there's no agreement as to the manner of sentence at all, either the length or the manner of service. So that's up to us. Sometimes they just have specific questions. You know, we agree that the defendant should be sentenced as range 1, which means they have no criminal history. We agree that sentences shouldn't run consecutively, but we need the court to determine the amount of time, or sometimes just whether it's probation or incarceration, or sometimes it's just about whether to grant judicial diversion.
And what if you're the judge and you see a plea agreement and you see that they've agreed upon a sentence and you are questioning that? What happens then?
Well, I've been on the bench all of 9 or 10 months now. I've not had a plea agreement yet where I didn't approve of it. And there have been a time or two where I've had a question. I've asked that question. You know, if something looks like something's been greatly reduced, or just the punishment doesn't fit the crime, so to speak, you can ask the parties those questions. However, you have to realize at the time you're taking a plea, most of the time the judge knows next to nothing about the case other than what the defendant is charged with. Sometimes if you recognize the defendant from prior appearances in court, maybe you happen to remember a little bit about their criminal history. But the reality is the district attorney and the defense lawyer know infinitely more about the facts of the case, what evidence the state really has to prove the case. And sometimes that's a big issue of why things get reduced, is the state knows that they're going to have problems proving someone guilty at trial. So you see it, but you're really in a position where you know the least amount of information. So you need to be really careful if you're going to disapprove of a plea agreement.
That's a really good point, Zach. Rule 11 gives us really unfettered discretion in rejecting plea agreements if we want to. The defendant doesn't have a right to a plea agreement. They have a right to determine if they're going to plead guilty or not guilty, and they have a right to a trial by jury. But if justice demands that the court reject a plea agreement, the court has that discretion. But Zach's exactly right. It's hard for us to determine when it's a plea before us, because there's very little that we know. The parties know the cases much better than we do. There's sometimes, only a couple times in my career, where I felt like the agreement would result in an injustice based upon the way it had been announced, but that's rare. It's just hard for us as judges to make that determination.
What about victims in pleas? Should victims know? Is that part of what the DA is supposed to be doing, is informing them that a plea has been accepted or not accepted? And sort of what is the role there?
Several years ago, Tennessee had a constitutional amendment that gave victims certain rights. And one of those rights is to be informed as to what plea agreements are, their terms. They'd be given a chance to come to court and express their pleasure or displeasure with that plea agreement. Now, they don't have the right to direct the lawyer and say and demand the lawyer, you can't do that, or you have to do this. But they absolutely have a right to be heard. They have a right to be in court, and they have a right to testify.
And I think that goes to another misconception. The district attorney's office is not the lawyer for the victims. They are the lawyer for the state of Tennessee. And sometimes there are disagreements. And all of our district attorneys have victim coordinators who do great jobs, but they should be setting those expectations of what sentences could be and should be. And they have to balance not only how a victim feels about the case, but it's more than just an emotional decision when we're making these legal determinations. The DA has a duty to argue what's appropriate for purposes of justice, not just how a victim feels about that particular case.
And along those lines, in that in that pre-sentence report that I talked about, there is a section for victim impact, and the victim has a right to fill that out, get that in the pre-sentence report. But the one thing that the trial judge cannot do is we cannot substitute our judgment for someone else's. And that really becomes critical, because in every victim impact that I've ever seen, one of the questions that the TDOC asks is, what do you think the judge should do as far as punishment? Well, that's the one piece of testimony that I cannot by law consider. I can't delegate that duty to somebody else. So we as judges have to be careful about that.
Yeah, that's a good point, Jim. One of the ways I handle that is after I receive victim impact testimony, particularly if it's been in a very emotional, very difficult case, often a homicide case, I start my sentencing judgment, which generally takes me anywhere from 20 to 30 minutes on a homicide, by addressing the victim's family. And I tell them, as a human being, I feel so much sympathy for you, but you need to know that I cannot let that affect my duties as a judge. And so what I'm getting ready to say is going to sound cold and calculating, and I'm just going to be talking about the law and years and certain factors. And it's that way by design. So I kind of warn the victims that I understand their emotions. I sympathize with them. Often not say, you're in my prayers, but then I have to shut that off. As a judge, you cannot consider that at all.
Yeah, that's right.
So let's we started talking a little bit about victim impact statements. So what exactly are they? Are they written? Are they oral? Does the victim get to make a choice?
Absolutely not. Unless you've been subpoenaed for a restitution hearing. If you've received a subpoena, you need to appear in court. But there are a variety of ways we can take that victim impact evidence. Sometimes it's a statement submitted to the TDOC probation officer that prepares the pre-sentence investigation report. Sometimes they give a written statement to the district attorney, and the district attorney reads that statement in court. Sometimes they appear and they want to give testimony. So there's a variety of ways they can be heard.
Okay, so when you're looking at your pre-sentencing reports that you've received, what are the key elements that you're really looking for as a judge? What's like the most important parts of that sentence when it's going to be an open sentencing or it's been a jury trial? So now it's up to you to decide the sentence. What is just personally, what is the key parts of that pre-sentencing report that you look at?
the law gives us all that guidance that we need. And so the first thing that you have to determine is what class of offense was this person convicted of? And let's use an example. Let's say they were convicted of aggravated assault. That's a Class C felony. So now the judge knows my sentence can be anywhere from 3 to 15 years in prison. And again, the general public might think, oh, I guess you just decide how bad you think it was. And if it wasn't that bad, you do 3 years probation. If it was really bad, you do 15 years in prison. Well, there's further steps that you have to take under the law. Then you determine what range of offender that person is. And so that is based solely on their prior felony history. And so if they're a range 1 standard offender, which means they have less than 2 felony convictions, then they're looking at a 3 to 6 year prison. So the law narrows that down. And then once you get to there are further factors you look at, enhancement factors and mitigation, that the judge should consider determining whether or not it should be 3, 4, 5, or 6 years. And then you get into manner of sentencing. And that's kind of, I think, the question you're really asking for, Barbara, is what are those enhancement mitigating factors? What really stands out to you as a judge? And I know for me, it's prior criminal history for sure. And Jim, Zach, I think it's probably one of the things that you look at first as well.
It's the first thing. Once you go through all those preparatory steps, then the first thing I want to know is what his or her history. And then, so once I work through that, I want to know, well, within that history, have they been given probation before? And if so, how have they done? And all that information is in the report. And then once I work through that, I go back and I want to know what the defendant themselves have to say in the report about sentencing, about what they have done, what they're convicted of. And then I just go from there. And then it's social history, work history, those kinds of things. But the hierarchy for me is you got to know what the prior record is so you know where they fit within that matrix. And then I want to know, well, have they been given opportunities before for probation, and how have they done?
One thing that's important to note, if someone is what we call range 1, which means they have very little, if any, prior criminal history, the statutory guidelines state that they should be a favorable candidate for alternative sentencing. However, that's an advisory guideline. We don't have to do that. And case law says that the burden is on the defendant to demonstrate that they are a good candidate for probation. So that's one thing that I always look at in these reports, is looking at it holistically. Can I tell that they're cooperative with the probation officer? Because if they're not cooperative with the probation officer by showing up to their appointment for the pre-sentence investigation report, or they're being dishonest with the probation officer, that automatically signals to me this person may not be a good candidate for probation, because they're not going to show up, they're not going to cooperate. Sometimes it may even put TDOC at risk by supervising this person. Those are all important things to look at as well. There's also a statistical report that they're required to include. We call it a strong R assessment. And that should demonstrate, based on a series of questions they're asked, whether they're a low, medium, or high risk offender.
So we're talking a lot about prior criminal history, and in the guilt and innocence phase of this case, the trial part, that's often excluded. Because, not always, but often the rules of criminal procedure say we're trying to decide if this person is guilty or innocent of this specific crime, so we do not let in evidence of prior crimes. But now in sentencing, this is what you're saying is incredibly important. So it is sort of a change where if you've been following a case from a trial standpoint, you may not have heard about this, you may not know this person's priors, but now at the sentencing phase, the judge is going to have a lot of information about priors.
Yeah, you move from a presumption of innocence, which follows through every stage of the trial, into I've either admitted guilt or jury's found me guilty. So that presumption of innocence is gone. So that person stands guilty of that crime.
And a lot of what we're talking about on these factors, Barbara, has to do to their amenability to correction and rehabilitation. And so one of the other pieces of information that we get in those PSIs is the defendant's drug and mental health history. And so that will often tell us, is this person that is struggling with substance abuse issues? Is it a treatable need that can be handled in the community? If so, what options do you have in your particular community to get this person counseling if it's a mental health issue, or to get them some substance abuse issues, which really is driving, in Knoxville, I'd say 75% of our crime.
And then in the reports, what opportunity does the defendant have to speak? I think we talked a little bit about it, but And from the attorney's standpoint, is the attorney going to put on evidence from the defendant saying that they do have a stable job, they are a good person in the community, that they think they are? So what's a good narrative from your standpoint as judges for a defendant?
It really depends upon what the defense theory is on the sentencing hearing. If it is, for instance, somebody who has struggled with substance abuse issues, it's helpful to the court to hear what a plan. Like here's what we have lined up: inpatient treatment for him, outpatient treatment. He has insurance can help get him into these programs. It's also helpful to hear, as Jim said, from that defendant. They can make a statement to the probation folks, TDOC, that will be included in the PSI, but they also have a right to allocute, to make a statement without being questioned by the state in the court before sentencing. And those things are helpful to the judge in determining, is this person really amenable to correction, or are they just trying to get out of trouble?
And again, that's going to be a key difference between the adjudication phase, where jury trial, where we rarely hear from the defendant. Honestly, they often take the Fifth Amendment, and there's a reason for that. But now in the sentencing phase, they do have the opportunity to speak to the court and say what they need to say, whether it's going to be judicial remorse or talk about mitigating circumstances or whatever they want to say, but they don't necessarily have to be cross-examined.
That's correct.
That's correct.
So do you hear a lot from defendants then in their sentencing phase? How often do you actually hear from the defendant, whether in writing or orally?
99.99% of the time.
Okay, so they do often take the time to speak. And what sort of mitigating factors do you consider?
It really varies greatly depending on what you're looking at. And I think the majority of what most of us see are, like Judge Sword said, drug-related crimes, or if it's property crimes, it's still driven by an addiction need. So what I look for is a track record. If that defendant is out of custody when they're sentencing, I want to know if they've gotten a job. What I don't like to hear is, if you give me probation, I'm willing to go to treatment. Because if they've been out of custody for an extensive period of time, they've had the opportunity to begin that in some way, or at least have secured an inpatient bed somewhere or started some sort of program. Sometimes they need probation's help for that, but the ideal sentencing situation for a defendant is saying, since this case has been pending, I've secured employment, I have participated in my own rehabilitation, and I'm not waiting on the court to make me do it. That is not an ideal candidate. That's also a rare candidate.
Very rare.
So we've hinted at it a little bit, but what are our options in sentencing? Obviously, there's jail time. There's probation that we've talked about. We've got community service, but what about fines and restitution? And how often are you able to use restitution, which is sort of, especially in a property sort of theft case, if someone has broken into my car and stolen my beloved bike? Am I going to get my bike back? I mean, my bike is gone. Let's assume we can't find it. Am I going to get money back from, I'm out my $10,000 bike? Am I getting it back? Am I not getting it back? Sort of when can you use restitution?
The statute encourages the use of restitution in sentencing, but we are limited to the ability to pay of that offender. So quite often, the folks who are committing these criminal offenses, whatever they've taken, they don't have it any longer, and they don't have the means to replace it. And so you can order restitution. Now, enforcing that is quite often hard to do. So you say you can't get blood out of a turnip. And at the end of their probation, if they haven't paid off all their restitution, then the victim can convert that to a civil judgment and attempt to collect in perpetuity. And they can't be bankrupt. However, again, a lot of these folks, it's hard to get the restitution out of them, just simply because they don't have the means to pay it or the ability to get a job to pay it.
That's another great example of an ideal defendant comes in, and I've had this before, where they have some large portion of the restitution in hand at sentencing to deliver to the victim. That is ideal, because the law specifically says that restitution is a form of punishment. So if we can get that part of punishment out of the way, that is something that's really important. And I think it also shows remorse, and it shows an acceptance of responsibility if they're walking into the courtroom prepared to start paying on their restitution at that time.
All right. So the big decision, I mean, obviously in some cases, it's going to be obvious that it's jail time for, certain felony, first-degree murder. You're going to go to jail. So you have to just decide the amount and the length of the sentence, and whether it's going to be opportunity for parole or not. But the hardest decisions when we're trying to decide jail time versus probation.
Sure. For me personally, that's the biggest struggle. When the law, it'll take you so far. It'll tell you, here's what your options are. And sometimes, as you said, Barbara, the options are clear. All you're trying to figure out is how long am I going to send you to prison. But we get a lot of cases where the court has the option of granting diversion, placing them on probation, doing split confinement where they do some period in local jail, or sending them to prison. That's when you really need to rely on the law and make sure that you're not making a decision based upon your own personal biases or because you've had a bad day, that you're able to set all that noise aside, go back, take the time, evaluate the facts of that case, evaluate the enhancement mitigation factors, look at the guidance that you've been given under the law, and make the determination on each of those factors. It sounds a little cold and calculating, and it should be. We don't want judges to make decisions from an emotional point. If you get angry at a defendant for something they did, you don't want to sentence them out of anger. However, if justice requires under the law that they serve that penitentiary a lengthy version of that particular offense in the penitentiary, then that's what you should do. You just need to make sure that you're following the law and letting that dictate you rather than your personal feelings about the case.
And when you're making the decision for jail time versus probation, can you hear from the defendant's family, the defendant's kids or spouse, and the impact that incarceration would have?
The defendant can put on proof, and I would let them put on whatever proof they want to, and if their family, in fact, the defendant's family regularly gets up and testifies about how they will be impacted if he is or she is in jail. And I consider that under whether the defendant has support in the community. Under that fact, there's a factor for that. However, it's like Steve said, you can't let, it's an emotional time for both sides, especially if someone's looking at potentially going to jail for a long time. And you can hear that proof, you can take that proof, but you have to listen to it, consider it, and then make your decision on an unemotional basis.
Yeah, I find that testimony from the defendant's family sometimes is the most impactful of that defendant when they start really coming to terms with the fact that not only have they screwed up their lives and the victims' lives, but they really hurt their own families too. And a lot of times you'll kind of see that light come on in their eyes that, wow, I really screwed up here.
Yep, that's true.
And so we've talked about how the legislature sets minimum and maximum sentences for a crime. When do you feel like you can go above a maximum or below a minimum?
You cannot.
You can never?
No.
Yeah, that's right. And so, there's something called especially mitigated offenders, but that's really just going to impact the manner in which the sentence is going to have. And that's one of the things that I think is beautiful about the Tennessee law is that the judges are given discretion within the ranges of the offenses and the range of that particular offender. But we have fairly consistent sentencing because of that the legislature said, we're going to give you some discretion, but we want to make sure that these offenses are treated the same throughout the state. And so the judge really, it's not like federal court where you can depart from the recommended sentence. Zach's exactly right. Here's the range. Here's what your options are within the range. And if you depart from that, then you're going to get reversed.
And to be clear, you can't even go outside the range. So the aggravated assault example we use, which is a Class C felony punishable by 3 to 15 years. If they're range 1, which means they have very little criminal history, if any, 3 to 6 years. I can't give them 7 years under any circumstance.
So let's talk a little bit about probation. What exactly is probation and what are the expectations of the defendant?
Probation, first of all, there are two forms. There's supervised and unsupervised. In criminal court, we're dealing with felonies. It's rare for us to see a lot of unsupervised probation, although for misdemeanor sentences, it's a lot more routine. And I tell defendants, because sometimes if they've been performing well on supervised probation, we, on rare occasion, will move them to unsupervised probation. I make it clear to them, you're still on probation. So if you're not following the rules of the court, you're picking up new charges, you can still have your probation revoked even though you're not going to see a probation officer. But most people, especially on felony sentencing, they're supervised by probation with the Tennessee Department of Corrections. So they're reporting regularly to a TDOC probation officer. They have their own officer. They're being drug tested regularly, if that's recommended, which in most circumstances it is. Probation will help them with resources. They'll help them with employment. They will help them. They'll refer them to a social worker if they need recommendations for mental health or alcohol use or substance abuse, those types of treatment. Probation actually comes to their home. It typically at least twice a year, sometimes more often, conducts a home visit, making sure that they are living in an appropriate environment. So probation is intense, but it's also something that, in our view, at least, it's easy to show up for probation, especially if it keeps you from having to be locked up.
So what kind of conditions can you put on probation? Can you be creative at all and match probation conditions to the specific defendant?
Well, sure. We do that quite often, particularly when they have substance abuse and mental health issues. We order them to enter treatment and take medication sometimes. We're allowed to do that. The Department of Corrections has a lot of discretion as well, too, on how closely they're going to supervise an offender. And they've set up different levels where they have just regular probation, where they may see them, once every few months. They have enhanced probation, where they're going to have them come in at least once a month. And then they've set up different levels. They also set up different treatment. Like we have a day reporting center in Knoxville where those offenders are reporting virtually every day of the business week. And it's almost a full-time job being on probation. And so they sort of structure within the Department of Corrections themselves a program of probation for that offender. But the judge can also say, you know what, I know you qualify for regular probation, but I want you to be on enhanced. I want you to be seen a little bit more. I'm going to order, a drug screen every week on you. And I'm going to order you to stay out of certain parts of the town and stay away from victims. So that's a standard one. I'm sure you guys have seen particular cases where you also make very specific orders to address the situation in that case.
Yes, I've ordered individuals to not be in charge of the finances of another, because sometimes we see that with financial exploitation crimes.
Yeah, the big requirement is that any condition we put on a defendant with regard to probation has to reasonably relate to the crime that they're convicted of. So I've had drug diversion cases where a nurse would work at a hospital and divert drugs, and one of the conditions of probation is you can't work in that field while you're on probation. Even if you get your license back, you can't work in that field. So we have a lot of.
And when do you utilize recovery courts or alternative sentencing? Is that always a possibility, or to just touch briefly on that?
It has to be a nonviolent crime. It has to be a non-sex crime, and this one requirement varies from court to court. But it can't just be a drug dealer. It has to be someone. Maybe someone was dealing drugs to support their habit, but then they have to go through a battery of tests. And they have to score, there's a matrix, needs versus risk, need being the need for treatment, risk being the risk to reoffend. And if they're high risk, high need, then they're a person who should be considered for recovery court if they meet those baseline requirements.
Yep. And that's true for our recovery court as well. We do take some people that have sold, just to either support their habit, or they have friends that have come over to use with them and they're selling part of their supply. We draw the line at what I always call entrepreneurs. We don't want entrepreneurs in our recovery court because we have a good base of business for them.
Interestingly, we're getting ready to start a mental health court in Knoxville in about 2 months. And so we don't have quite the same restrictions as the drug recovery courts have. And so we're not limited by the offense they were convicted of. We're really more limited by the nature of their mental health issues. So we're looking at folks who have serious mental health issues that need to be treated in the community. But you also have to balance that with the ones who are too severe to be safe in the community. And so it's going to be interesting to see how those decisions are made, because the district attorney's office has a right in the mental health court to step in and say, we object for whatever reason, for this person being in mental health court, then that person wouldn't go through the process. And so we're experimenting with it. We're expanding it. That's happening all over the nation. We're trying to figure out, who can be really successful in these recovery court type situations, and who really needs to be guarded more closely through incarceration.
And so what happens when someone's on probation and and they violate the conditions of their probation?
So it depends on if it's a technical violation versus a non-technical violation. A technical violation might be something like I missed an appointment, or I missed a drug screen one time, or a payment of restitution. That's a technical violation. The first time it comes to our attention, what's interesting is most of these are actually handled internally at TDOC via their sanction matrix before it ever comes to our attention. So once they're severe enough, they'll send the technical violations to us. The first time, we actually don't have the ability to incarcerate them. We can impose stricter conditions of their probation, but we can't put them in jail for one technical violation. The second time, we can do 15 days, and it goes up each time. For non-technical violations, which is what we see the most of, that consists of absconding from probation. It's more than I just missed one time. It's I've disappeared, probation can't locate me, I'm gone. We also have new offenses that are a misdemeanor or a felony. That is a non-technical violation. And then we have anything that is a zero tolerance offense for TDOC, which is primarily testing positive for meth. Those all come to us. So as a probation violation where we have a little more ability to do something. So we can extend probation by up to a year. We can remand someone to serve their entire sentence or anything in between.
So from a sentencing hearing on a difficult case where you have a difficult decision to make, just from your opinion, what is a good sentencing hearing? When do you have a sentencing hearing in a difficult case and you stand up and you're like, that was a great hearing. I now have what I need to make that decision.
A lot of times the lawyers will just get up and they'll make arguments and say, here's this enhancement factor, it applies. And the defense will argue, we think this mitigation applies. And then you go back to your chambers and you're sitting thinking through, well, I heard them say that, but I haven't really seen any evidence of that. And so a good sentencing hearing, like Jim was saying earlier, is both sides present evidence. So they will, if the state wants to rely on prior criminal history, they don't just rely on what's in the PSI. They'll actually bring in certified copies of the judgment. They will, put on additional proof that wasn't heard during a trial. And certainly if it was a plea, they can call witnesses, and those witnesses can be cross-examined by the defense to help the judge to understand the circumstances of that offense. And from the defense perspective, to hear proof on mitigation. So we actually have facts and evidence that we can really rely upon. That is more helpful to me than just hearing the lawyers argue certain positions and saying this is what we think you ought to do. Well, give me something to base that on under the law.
I think that Steve summed it up perfectly of what we're really looking for, especially when we have a case that came to sentencing by way of plea. We know virtually nothing about the facts of that case, but the facts and circumstances are something that we're supposed to consider. What ends up in that pre-sentence report most of the time is either language from the indictment or maybe a couple of paragraphs that came from the officer's original arrest report. And sometimes we get a defendant's version of events and they're wildly different, and you've got to figure out how to reconcile that with no proof whatsoever. Another thing that I've always found helpful is when the parties file briefs in advance. They're supposed to file in the record if they're asking for enhancement or mitigation factors, but a good hearing sets it up where they're arguing for which factors should apply and why. We have to consider the statutory principles of sentencing when they make specific arguments in their briefs about how we should apply those to this particular situation. That's always really helpful for me if the parties can set it up well in a brief in advance.
Totally agree with all that was said.
So how do you set what rules apply? I mean, if obviously you have to set your docket, you have to set your day. So if I'm an attorney, how do I want to put on evidence? How do you set, what kind of rules apply? And this is not necessarily the rules of criminal procedure are going to apply. So how do you set that in your court? Like how long we can have, how many witnesses I can bring, whether there's going to be cross-examination. How do you set rules?
Well, that depends upon the case. If we're dealing with a first-degree murder sentencing hearing, I'm going to take all the time the parties need. Now, if you come in here on a DUI first and you're going to want to spend 2 hours, you're going to see a judge's eyes glaze over, and it may not be that helpful to you. So, the rules of evidence are certainly relaxed during a sentencing hearing. you can hear a lot more testimony that you wouldn't really hear during your trial. But really, it's just proportional to the offense that we're dealing with. Generally, I don't cut attorneys off. They will often pick up on my body language that I've probably heard enough. But, it's an important decision for the victims and for that particular defendant. So I want to make sure that they have the opportunity to be heard.
Yeah, I normally don't cut the lawyers off.
For us, we may have 100 cases on the docket that day, but whoever is before us in that moment, for them, that's the most important case of the day, whether it's the lawyer, the defendant, the victim. They want to know that the court is listening. So it's important to give them the time that they need. And you do get some attorneys that tend to go on too long, because this may shock people, but attorneys like to talk too much from time to time. And you can kind of signal to them when you understand their point and make them feel you have been heard, so you don't need to keep talking because I understand what you're saying. But you typically want to give them their time because it's a matter of liberty.
Back to creative solutions for fines, community service, restitution. When have you used a particularly creative solution? Probably most likely along lines of community service, obviously like a property crime type of an example. When have you used creative solutions, and when can you?
There's some discretion that the judge has on that. You have to be careful, make sure you're doing something that just isn't your idea. That sounds like a great idea for this particular case. And sometimes that's how judges get in trouble, by going outside of their authority. But particularly if I'm dealing with a young defendant, under 20, 19, 18-year-olds, sometimes I'll try to be creative with them to try to help them understand the impact of their behavior. And community service is often one of those that you can use to say, you've taken from this community, you need to give something back to them. But when you're dealing with folks who, are longtime criminal offenders, you're not going to be too creative to to come up with some idea that's really going to change them around. It's been my experience anyway.
I agree. And it does seem to be, especially the younger first-time offenders, that you're trying to impose those creative solutions because you're trying to keep them from becoming a convicted felon. A lot of times that's who's on a diversion. I had a young defendant express they needed a GED one time, and in order to keep them on probation, I made it a condition that they needed to enroll in GED classes and not just pay lip service to the court in a sentencing hearing, but actually put the pedal to the metal. So
what cases and with this question, so what cases are the hardest for you to sentence?
Well, the hardest, the emotionally obviously ones when there's been a life taken, but the hardest ones as a judge are the ones where you have so much discretion, particularly like, let's take the aggravated assault that we started the podcast with. You've got somebody who's committed a serious violent criminal offense, but the options, you can actually get diversion for that. It's a Class C felony. You can also send them to penitentiary without parole for a lot of these. Now it's 100% offense. And so you have such wide latitude. And so for me, those are the ones that are the hardest, because you are going to have a tremendous impact on the life of that person and the experience of the victim through the criminal justice system based upon that decision. And so the ones where you can go anywhere from a diversion to send them to penitentiary with no parole, to me, that's the hardest.
There are times, and there's certain defendants where everything does seem to be stacked against them. You have victims there that are very upset. You have a district attorney that is aggressively pursuing the case, but you have a defendant who is showing you enough that you think this may be the time where they're about to turn it around. And then what you're really doing is you're taking a moment within your discretion and within the confines of the law to actually show a little mercy. And sometimes that's the hardest thing to do, because you're less shielded from criticism from showing mercy than anything else you do. So that's always the toughest decisions.
The discretion part of it, that component of it, is what makes sentencing decisions difficult. Trying to balance what the defendant deserves, what the victim needs, that can, and if you have if it's first degree murder, it's easy. You get life with, or you get life without. One or the other. But below that, when you have to balance those two competing interests, and you have to make sure justice is served, that's when it gets difficult.
And that the interesting thing to me is as I was sitting here thinking about, that's the hardest part, when when it's within our discretion to do pretty vastly different things. It's also what I think energizes me as a judge, because we don't want robots up there. We could ask AIs, Chat GPT, say what's the appropriate sentence for this, and we would end up with more unjust sentences than relying on human beings sitting up there thinking through the law and thinking about the particular cases. And so I don't mean to denigrate the discretion that we're giving. It's very important, because without that discretion, you're going to end up with many more unjust sentences. Like Zach said, you're going to miss out on the opportunities really to change somebody's life, because this is the time that it really clicks with that person. And instead of sending them penitentiary, you've created a productive citizen for our community.
Well, thank you all for joining us for this edition of Tennessee Court Talk.
Thank you.
Thank you.